Good morning, Your Honors, and may it please the Court, Sanaz Charzay on behalf of Appellate Six Flags Theme Parks, Inc., Six Flags Entertainment Corporation, and Park Management Corp. On appeal this morning, Appellate appeals a very narrow issue as to the scope of the District Court's order related to oversight, monitoring, and external auditing of Appellate's ADA compliance after the permanent injunction was issued on February 28, 2025. The narrow issue before this honorable court is whether the order permitting continued monitoring, external auditing, and court oversight of ADA compliance by both the District Court and individually by Mr. Patterson as to the external auditing for a 3-year period was an error. Appellate can...
Let me ask you this. Our standard of review is abuse of discretion, correct?
Correct, Your Honor, as to the issues related to the factual determinations in the record.
Aren't we reviewing what the district court judge did?
We are reviewing what the district court judge did, and in this case, that's important here because there's no evidence at all in the record or analysis in the record as to why the 3-year specific external auditing and mandatory...
Did you object to the district court? Did you say, Judge, 3 years is just too long because it's burdensome, it's a hassle, it's unnecessary. Did you bring any of those issues to the attention of the district judge?
Yes, Your Honor. My response to that would be twofold. One, the district court's procedure that was mandated was that each party submit its own proposed order. In our proposed order as a compromise provision, what occurred is when we asked for a 1-year, if the court was going to implement external auditing or monitoring, that it would be for a 1-year period. The court overruled that by implementing a 3-year period without any discussion or legal authority.
Did you offer any? The other side offered 3 years, right?
Correct, Your Honor.
And I thought the judge asked for, sort of objections or whatever.
The judge asked for objections as well as a proposed injunction.
Right. So when they submitted their order, did you object to these provisions?
The objection was within the proposed. We maintained the objections within the proposed injunction offered by the appellates in the court below.
So let me follow up on Judge Pius's question. I see, for example, on ER 81, which is what you submitted, that you did redline the proposal from 3 years to 1 year.
Correct,
so
Your Honor.
You suggested 1 year. But I don't see anywhere, and refer me to someplace in the record if I'm wrong, but I don't see anywhere where you objected to the audit provision. As far as I can tell, that's also on ER 81. You didn't redline the audit provision. So where did you object to the district court to that provision?
That provision wasn't specifically objected to in the record. However, there was an overall objection as to preserving the waiver of appellate rights.
I'm personally not concerned that you waived this. The judge said you need to meet and confer. You were trying to meet and confer. You were doing what the judge said. The judge said you got to preserve all your appellate issues. But waiver is a different question to me than whether you said I'll make up a number here, I'll just invent a number. You objected to 10 provisions, I'm just making that number up, in the proposed PI, and this is one you didn't redline. So how did the judge even know that on the audit provision you had a problem with it? Yeah, you preserved your right to object to everything, but on this one where the judge said meet and confer, tell me where you have a problem, some the judge went with you, some the judge went with your friend, but how would the judge even know you didn't like this provision?
Well, I think the audit provision encompasses the period of time provision. So if the audit provision, although there's not a specific red line to the audit provision, it follows that any external auditing, external oversight would be limited to that 1 year period. And when the court rejected the 1 year period and adopted a 3-year period without legal analysis, then that made it ripe for review on appeal. As to
Well, I mean, I understand your argument as why the audit provision should be, based on your objection, should be 1 year as opposed to 3 years, but you've said in your brief that the audit provision should just get thrown out entirely, right?
Well, I think the audit provision, there's not a legal standard that allows for the audit provision. And so for that reason, because there's no legal standard that allows for the audit provision and there's no factual record that developed the audit provision.
Didn't the district court have discretion to include it, though, based on her findings and factors and conclusions of law?
I agree that there's a abuse of discretion and the district court can include it.
Sure.
However, it needs to be based on the record and an analysis of a factual record that's developed. And in this case, the audit provision that was offered by Mr. Patterson was added after the fact, after the November 2024 order that invited a proposed injunction for internal auditing. The court never invited an external auditing provision. That was after the fact, after the record was developed in the trial.
It looks to me like the district court did a careful review of the proposed injunction from the plaintiffs and your proposed injunction. She had written careful findings of fact and conclusions of law, and you can tell that by reading her order. And she was very familiar with the case. No question about that. And when you read what happened here to the petitioner, and one of her first observation was that the ADA has been in effect for many years, but it seems Six Flags hasn't quite seemed to caught on yet after all these years. Maybe she just thought in her discretion that this was the best way to sort of get Six Flags into line, at least with respect to the petitioner here. She clearly adopted your view that any order had to be limited to this particular location and not Magic Mountain in Southern California or elsewhere.
Yes, Your Honor.
So I mean, she had lots of discretion here, and there was quite an interesting record here.
I agree with you that the court exercises discretion as to certain aspects of the objections on both sides and as to the proposed injunction on both sides. We are not disputing that underlying injunction or the grounds for the underlying injunction. The narrow issue is whether or not there is supporting legal authority or a factual record, which I don't believe was...
Legal authority says that what she did was unlawful.
Well, I don't think we need to determine whether it was unlawful. I think the issue...
You just said that there's an absence of legal authority for what she did.
There's an absence of legal authority for the court to impose an auditing requirement for a 3-year specific period without any analysis or support in the record.
But counsel, it certainly is the law, as I understand it, that if the district court has made a clear error of law, that is a per se abuse of discretion. We apply something like that standard in many contexts. But as I look at the record here, there was an entity which knew about the ADA, but in certain circumstances, including involving the plaintiff, paid very little attention to it over a significant period of time. And from my look at the record, it didn't look like this was some sort of strike suit plaintiff. It was a plaintiff who was trying to enjoy amusement parks. And there was a lot of facts here. And the district court said, I think we need 3 years. And I think it'll keep your eye on the ball that if a third party like the plaintiff's lawyers can come in and look at stuff, it's more likely that you're going to do what you need to do. So I don't think there are any magic words the district court needs. So what is it about this, for example, that is so overly burdensome that the district court doing this is a clear abuse of discretion?
The burden arises from the court having to be involved with the ADA compliance for a 3-year period of time. And beyond that, their order allows upon any request by the plaintiff and now appellee's counsel to asked to audit these records upon 30 days' notice for an unlimited period of time. At this point, we are now 1 year past.
Although what the order says is what they can review, unless I'm misreading it, are only the records that are required to be maintained by the PI order, right? It's not like they can go in and give you a list of 50 things that aren't required to be maintained. It's they get to audit what the order requires you to maintain. Am I misreading this?
No, Your Honor, I agree that it's what the order requires to maintain, but at the same time, appellate is still under the oversight of the court, even though it has submitted these quarterly compliance reports and will continue to be over the oversight of the court for another 2 years. Whenever a plaintiff has a request without any limitations other than 30 days to comply.
Is there anything that would stop you from, say, after 18 months or after 20 months coming back to the court and saying, look at all of this good stuff we've done. Look at how much we are in compliance. Look at how much we're complying with the ADA. Look at the fact that plaintiff and their lawyer have no complaints at all or almost no complaints about what we've done. Why don't you reduce the number from 3 to 2? Is there anything that stops you from doing that?
The order itself, I think, would stop us from doing it because the court has indicated that we would need to show significant cause or good cause in order for a modification, and that the same arguments that were presented with today in this appeal would arise if we try to modify it later.
Counsel, let me come at this from a slightly different perspective, and that is, how is this different from parties in a trial preparing competing jury instruction proposals, and the court then chooses one or the other or modifies the court's standard instructions? Don't we require counsel to make a specific objection on the record once the court chooses which way it's going to go? As I understand your argument, it's simply, well, we redlined it, and that's good enough. And I'm not sure that gets you there if my analogy to proposing jury instructions holds.
I understand your analogy, Your Honor. And jury instructions, and when both sides submit proposed orders or proposed jury instructions or proposed verdict form, and they present that to the court, that's can be enough to preserve it on appeal. But in this case,
well, we require a specific objection to be made, or you have waived your objection to that particular formulation of the instruction. And I think it's directly analogous to the situation here. You had to do more than simply submit a competing proposal.
We submitted a competing proposal with a reduced scope as to the time period. So I think if we
But you didn't once the court chose 3 years, you didn't specifically say, Your Honor, we object to the 3-year period, and I'm preserving that objection for appeal.
No, I agree with you. There's not a specific line or a specific form in which that objection was provided for the 3-year period. It was included in the proposed injunction order, and the court also allowed us to preserve all of our rights on appeal and included that specifically in the injunction itself.
I mean, I'll take Judge Bennett's question with regard to the audit provision itself. You didn't redline that. And
Correct.
So how would the court know that that was even at issue without counsel specifically directing the court's attention that we object to the audit provision?
Well, the audit provision would be under the 1-year period of time
I'm saying
as well.
after the court essentially said, I'm going to go with 3, I think it's incumbent upon you to say, well, we object to the 3-year period.
Well, I that would have required additional post-order briefing, or which wasn't invited by the court at that point in time.
Counsel, let me.
Yeah, no, go ahead.
So I should know the answer to this, and I apologize for not knowing the answer. But you submitted your red lines. Was the first time you learned as to which the court was accepting and which it wasn't was when the court issued the PI itself? or did the court say, here's my proposed PI, do you have any further objections?
I don't believe it was the latter. I believe it was the former, that each party submitted their proposed injunctions, and then the court issued its order.
So the first time you learned that the court had rejected some of your proposed changes was when the court issued the PI.
That's my recollection of the record and the proceedings.
Okay, well, your friend can tell us too. So if that were the case, the only method you would have had for objecting was essentially moving for recon.
Correct, or additional modification or appellate action.
All right, we've taken up a lot of your time. We'll give you 2 minutes for a rebuttal.
Thank you, Your Honor.
May it please the court, Andrew Rosinski for the appellee, Mr. Patterson. The court raised a lot of the questions and issues that I've raised in the brief and asked very great questions, and I don't want to be repetitive regarding things that were already discussed. But to put a finer point on things, the court is correct in saying that the monitoring provisions that are largely at issue at this appeal were not redlined or specifically objected to. There were 2 very specific objections that the appellant did make on the record, and that was to the nationwide injunction and to the to the use of video remote interpreting. And those were the 2 specific objections.
You don't consider a red line an objection?
I do not consider a red line a objection.
The judge adopted what I would view as a practical approach to this, where the judge said, we have a winner, we're going to have a PI, and I want you guys to see if you can agree on a compromise, but she wrote, nobody's waiving anything, because she wanted people to try to see if they could agree, even though there was a winner and a loser, right?
Right.
So why wouldn't, I mean, this doesn't go to whether 3 as opposed to 1 is an abuse of discretion, but why wouldn't redlining 3 and putting in 1, why wouldn't that be sufficient to alert the district court to, we don't think 3 is the right number?
Well, I think it could, and I think the jury instruction example is a very good example.
Well, except, I mean, one difference is that there is a specific rule of criminal procedure which requires certain actions in order to preserve for appeal an objection to a jury instruction. I can't remember if they have the same rule in the rules of civil procedure, but in criminal procedure, you don't do A, B, and C. You can't come to us unless it's plain error.
Yes, Your Honor. I think in this context, I think that it could, even arguing that it was an objection, I think that the court gave very careful thinking and gave meticulous factual findings as to why she believed, based on this record, that the monitoring period was warranted in her decision.
Yeah, why don't you tell me about that? And I mean, 3 seems kind of long to me for a case like this. The fact that it seems kind of long to me doesn't mean that even if my colleagues agreed it was kind of long, that it was an abuse of discretion. But why in a case like this do you need 3 when there are procedures that have to be in place? There have to be changes that are made if they're not complying after 1 or 2. If that were the number, you could ask the judge to extend it. I mean, how have things been going?
Well, they haven't provided us access to the underlying records. We're only seeing what they're filing on the docket.
Have you asked?
I have asked, and they've said that pending appeal, they are refusing to provide those records.
Okay, so you're talking about the audit provision?
Correct.
So you have made, under the PI, a request for the records that the district court ordered them to provide you, and they've said we're not going to give you those pending appeal?
Correct, Your Honor.
I thought they said they didn't have any because in the time period that had passed, they hadn't had any requests for accommodation.
There have been quarterly reports where there have been requests for accommodations that have been submitted to the district judge through these quarterly reports. So there would be records that.
So some periods yes, some periods no.
Correct,
Is
Your
that
Honor.
what you're saying?
Yeah,
But you've made requests and you haven't gotten anything.
correct. We made a request and we were told that they will not be giving us any records until this appeal is resolved.
And I assume your strategic decision is you're going to wait to do anything about it till you see what we do.
Correct, Your Honor. And going back to your original, the findings that of systemic failure is because these requests, just from the monitoring periods, they come and go. You're not going to get a request every day for a sign language interpreter at these parks. They're going to come maybe once every 4 months or 6 months or,
But
8 months.
We're not talking about a huge amount of work here in order to respond to your requests.
Correct. Over the 3-year period, there might be only 10 requests,
Right.
over the 3-year period. So this is not a onerous, in our view, burden for them to do this. So if the court wants the factual findings that we believe support this, one thing that was mentioned that after, the quote about after all these years, they don't seem to understand their obligations. Even at trial, they were pushing back regarding, their duties and obligations in doing this. One of the things that was striking is at trial when I asked, when did you, do some research on providing an interpreter for deaf people, and their corporate witness said last night. At trial was the first time that they had looked into whether interpreters can be provided. They could have vendors that could provide those services. And so the court here did very careful findings, and I can point the court to, 1 ER 23, 1 ER 24, 1 ER 26, those are records to kind of that show the factual findings that the court had made to support her findings, and I think they're reasonable under these circumstances. And over a 1-year period, we might have only had 1 or 2 requests, and that might not be enough to determine, okay, they know their obligations, they know what to do, they're good, and we can send them off, and they'll be fine moving forward. So, if the court doesn't have any further questions, I'll
No, I don't either.
Thank you, counsel.
thank you.
Why don't you wait a minute before starting the clock? I'm going to ask this question. Here, come on up. This question, not going to use your 2 minutes for it. Is what counsel said right? That he has made requests, and your response to him is that notwithstanding that there's no stay in effect and notwithstanding that this is a PI order, you're not going to do anything in response to his requests until we rule? Is that accurate?
No, Your Honor, that is inaccurate. My firm has not received any request for review of the records or implementation of the auditing provisions.
That was my recollection of what we had been told in the briefing, but I was unclear about whether my recollection about what we had been told was correct or not. So thank you.
And
go ahead.
And
So
I
how
want
do we
to
resolve this? He says he did, you say he didn't.
correct, Your Honor. And I want
Do you
to,
want to take an oath here and step
well,
up?
I could represent that we
testify?
didn't, but I think that is, when I was thinking about this at counsel desk, why we need a remand for the court to fully develop the record here. We have now a
we
1
we
year.
can start the clock now.
Thank you, Your Honor. We now have a 1-year compliance period. The district court has adequate information with a developed record post the permanent injunction order to see if we are in compliance. There has not been any auditing request, but if counsel believes that there is something that we should have looked at, we didn't receive it, whatever it may be, that's for the district court to look at upon remand to see if that 1 year that we have now elapsed and participated in was sufficient to meet the goals of the permitted
Well, I
injunction.
presume, counsel, that your client and you are not going to take a position that they don't have to comply with the PI order until we rule
I
if
agree.
there's no stay, right?
I agree. We haven't asked for a
Yeah, no,
stay. I've actually been waiting for an audit trigger. So I've been cognizant that that might come in, and we haven't received one. And there's certainly never been anything developed in the district court record that we're not in compliance. So I think that now that we have a 1 year compliance period, the district court can look at the record to see if we need a 3 year compliance period to meet the goals of ADA compliance. And I think that that record wasn't developed the first time around, but on remand, that's the very specific issue, is whether that 1 year compliance that's already occurred would be sufficient to meet the goals of ADA compliance.
You keep saying 1 year, but the order says 3.
The order says 3, which we
And that
believe.
clock started when the district court issued the preliminary injunction.
Yes,
I just have one minor question for you.
correct.
The district court called for Patterson to file a proposed injunction first, correct?
Yes, well, I believe it was simultaneously.
That's what I was going to ask you. Where is it? Were you called? Where did the district court order simultaneous proposals, or did the district court order plaintiff to file
Plaintiff-
first, and then you file a response?
I believe that plaintiff submitted it to us first, informally, and I would have to clarify that, but my recollection is that plaintiff submitted us formally, and then we filed our objections and a response simultaneously. So the meet and confer occurred outside of the district court filings before the actual filing occurred, and then there was a simultaneous.
And there was never any discussion about the 3 year term?
There was a discussion as a compromise of making a 1 year term, which council did not agree to.
And in your response, you didn't really discuss that, did you?
We didn't have a separate filing as to the objections, but there wasn't a separate filing
But
There's
you-
something here, there's
requirement.
something here titled Defendant Status Report and Response to Meet and Confer Results, Ray Proposed Injunction.
Correct. And that was the proposed injunction that we offered to the court with the 1 year.
And that's where you redlined it on ER 81,
Yes, I believe
suggesting
so.
one
But you
rather
knew he
than
was
three.
you knew he was planning to request 3 years.
He had already submitted a 3 year as well, yes. So that's why we
But this-
redlined it to 1 year.
My point is that I didn't see anything in this document that I just identified that says, we don't need a 3 year.
I agree, there wasn't a full discussion on that 3 year, but there was the 1 year provision that was redlined. And I agree with Your Honor that we didn't have a separate objection form or anything related to a separate briefing on the 3 year. It was within the red line of 1 year.
Counsel, has this case been reassigned to a new district judge? Because Judge Mueller has retired, has she not? She was the judge who conducted the bench trial.
Yes, I actually don't believe that we've received the notice of a reassignment.
So if this goes back, it's not going to be heard by her.
That's interesting, Your Honor. Yeah, I don't believe that we received a notice of reassignment.
And that's a problem because she was the one who heard the testimony at the trial since it was a bench trial.
We would have to resubmit certain evidence as to this narrowed issue to develop a record, which is happens if the if we don't
Counsel,
have.
even if there's no remand, I mean, it's up to you what to do, but I don't see anything in this order which would prevent you from asking a newly assigned judge, even if we just simply affirm the PI order, to say things have changed. We think you should relook at it and reduce the number to 2 years. I don't see anything in the PI order that prevents you from doing that, is there?
I believe that we might have a procedural issue of doing that if that's not included in any opinion.
Is there a final judgment in the case?
Judge Mueller did enter a final judgment in the case.
Okay, yes, okay, so if there's a final judgment, then there would be a problem. I apologize.
So I think that that's why the appeal was very important for us to.
No, you're right about that if there's a final judgment, but I still think even with a final judgment, you still could go in and seek a modification based on changed circumstances, but
Of the injunction.
of the injunction.
The injunction as to.
Because the judgment allows the injunction to be entered. The judgment covered other matters as well.
Correct.
Damages,
And those have been satisfied.
right.
Right. So we satisfied
And
damages.
she authorized the issuance of an injunction, which was what we're dealing with here. And I think the Federal Rules of Civil Procedure 65 always allows the parties to go back and ask for modifications of the injunction.
I suspect we've all seen cases where it comes 20 years later.
Yeah.
And I think that could be a procedure, but I do see some hiccups in it, that if there's an appeal, depending on how the appellate order is brought down, whether that would be any preclusion in arguing a potential modification as to the time period.
All right. Well, we thank counsel for their arguments. The case just argued is submitted, and with that, we are adjourned for the day.